Good morning, ladies and gentlemen. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to the 5th Congress of the World Conference on Constitutional Justice, and Peace. My name is Wahyu Wiwoho, and it is an honor to me to be Master of Ceremony on today's event. Your Excellency, the Chief Justice of the Constitutional Court of the Republic of Indonesia, Anwar Usman, and ladies and gentlemen. To start our agenda, it is my pleasure to invite the Minister of Foreign Affairs of the Republic of Indonesia, Her Excellency Retno Marsudi, to give her honorary speech through a video. Right, ladies and gentlemen, before we begin the video, I would like to preview you as a video of how wonderful is Indonesia.
Under a clear blue sky, in a vast expanse of lush land spanning hundreds of miles, clusters of beautiful islands from Sabang to Merauke. Natural wealth abounds. Illuminated by the sun's warm light from the eastern horizon and full moonlight when night falls. People of various religions and beliefs coexist. United hand in hand. Diverse religions, beliefs, languages, customs, and cultures live in harmony. Tolerance, mutual cooperation, and respect reflect tradition and essence of life. Pancasila is constantly observed as the foundation of state life. As an ideology, Pancasila guides the nation to its goals. The values of nature. People and religion are upheld. And a lovely and peaceful symphony on a land on which God bestowed his blessings. Indonesia.
Right, ladies and gentlemen, to open our agenda, it is my pleasure to invite the Minister of Foreign Affairs of the Republic of Indonesia, Her Excellency Retno Marsudi, to give her honorary speech to a video.
Your Honor, Chief Justice Anwar Usman, President and Judges of Constitutional Courts, distinguished delegates, colleagues, ladies and gentlemen. I'm so honored to address the 5th Congress of the World Conference on Constitutional Justice. I apologize for not being in this very important gathering in person due to conflicting schedules, but I will join you all in person with my President later this afternoon. Excellencies, ladies and gentlemen, Indonesia views constitutional justice as a key element in achieving global peace, equality, and justice. These values are reflected in our very own constitution and serve as a fundamental guiding principle for Indonesia foreign policy. Therefore, today's Congress is crucial, especially as we are at the very fragile state of the world. War among nations and widening distrust is the current reality. International law is neglected. Food, energy, climate, and financial crisis all happening at the same time. During the pandemic, interstate conflict and violence are globally on the rise, with active armed conflicts occurred in at least 46 states in 2021. These challenges are multiplying factors for injustice. Global billionaire wealth grew by 4.4 trillion US dollar between 2020 and 2021, while more than 100 million people fell below the poverty line. 40% of developing and least developed countries will not achieve the same level of economic recovery with the developed world. The question now, how can constitutional courts contribute to address current global crisis and attain global peace and justice? First, by creating conducive environment for peace and social justice. Excellencies, ladies and gentlemen, protection of human rights and safeguarding a functioning democracy are preconditions for peace and social justice. The pandemic has brought unprecedented challenges to these preconditions, including in established democracies. This follows a trend of democratic backsliding for 16 consecutive years, as mentioned by the 2022 Freedom House report. The global pandemic has also brought question on the balance between maintaining human rights and saving lives. Undoubtedly, there is a nexus between democracy and protection of human rights and the establishment of peace and justice. As the democratic peace theory suggests, democratic states tend not to go to war against each other. Therefore, as a guardian of constitutional justice, Constitutional Court has a crucial part to play to solidify the pillars of democracy and protect human rights. This has been Indonesia's foreign policy in the last 15 years through the Bali Democracy Forum. Through Bali Democracy Forum, we continue to advance democracy and human rights in the region. Second, by ensuring paradigm of collaboration and peace. Colleagues, we must leave the post-Second World War paradigm in which interaction among countries is based on distrust and containment. Conflict in Ukraine is only a symptom. Chaos and war can happen everywhere. If we continue on this path, global peace and stability will be impossible to achieve. During the 77th UNGA last September, I offer a new paradigm as a transformative solution, a paradigm of win-win, not a zero-sum, a paradigm of engagement, not of containment, and a paradigm of collaboration, not of competition. This paradigm starts with upholding respect to international law, in particular, the fundamental principles of sovereignty and territorial integrity. This paradigm will ensure that disputes will be settled on the negotiating table rather than the battlefield. With this new paradigm, we will also achieve strong recovery for all and no one will be left behind. Therefore, I view that constitutional courts can play a significant role to ensure countries' adherence toward rule of law. Constitutional Court also plays a crucial part in ensuring countries to observe international legal obligation, which in turn help shape countries' peaceful behavior and nurture the paradigm of collaboration. Excellencies, ladies and gentlemen, we cannot speak of peace without justice. We cannot speak justice without peace. These two sides of coin are inseparable. Constitutional courts play a crucial role in ensuring that both sides are attained. On that note, I will end my remarks and I wish you all a successful deliberation. I will see you again today. I thank you very much.
Right, ladies and gentlemen, excellencies, let us move to our first discussion with the theme of sources and jurisdiction. The discussion will be led by His Excellency Omar Belhaj, the President of the Constitutional Court of Algeria. And I would like to invite all the speakers. First one, His Excellency Snus Dur, Secretary General of the World Conference on Constitutional Justice. And also His Excellency Omar Belhaj, President of the Constitutional Court of Algeria, and His Excellency Anwar Usman, Chief Justice of the Constitutional Court of Indonesia, and Her Excellency Simina Tănăsescu, Judge of the Constitutional Court of Romania, also Her Excellency Joana Fernandes Costa, Judge of the Constitutional Court of Portugal.
بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين السيد المحترم رئيس المحكمة الدستورية لأندونيسيا، السادة رؤساء المحاكم والمجالس الدستورية للمؤتمر العالمي الخامس، السادة والسيدات الحضور،
I think the interpretation has not yet started. Are you okay? Interpreters, please say something. Interpreters, please speak so those that we hear you. Yeah? I have nothing. You have? No, we don't have anything. I tried the channels 1, 2, 3, 4, 5, 6, 7. I have no sound. The technicians, please, could look into this. I don't hear anything.
Lihat channel berapa, Pak?
6.
Bapak bisa dengar?
Okay.
Bapak di channel 8 Indonesia. Arabic 7.
Okay, we have
Seven,
now
yeah.
new equipment here. If the interpreters
Seven.
could please say something again. Okay, I hear number 2. Okay, it seems to be okay. Yeah, so we had,
Okay.
this is better one? Okay, let's suppose it's okay. Thank you. Please. No? Sorry, mister. There's still nothing on this one. I have heard French, so at least. I hear German, but in very German and very bad quality. Sorry. Yeah, it's certainly not the fault of the interpreter. Yeah. J'entends la cabine française, ça semble fonctionner, le numéro 2. I do not hear 1. I heard 2. I heard... Yes. 1 is okay. 2, we heard already French. 3, Deutsch. 4, channel 4, please. No 4 yet. I try 5. No 5. 6, please. No 6. 7. No 7. I hear only channels 1, 2, and 3. Yeah. 4 is nothing. 5, nothing. 6, if you speak, please. Nothing. 7, nothing. So we have 3 languages, but we would need 7.
And which
language you will need?
For me, it doesn't matter. It's for everyone.
Okay.
Yeah, everything has to work.
Okay.
I try again 4. No. If you in the room hear 4, 5, 6, or 7, please tell me, but I have only 1, 2, and 3. Could you, it seems to be 4, if you could speak again 4.
C'est comme s'il y avait des interférences. Parce que quand on prend le matériel de la voix qui marche, quand on l'apporte ici, ça marche plus.
Ah.
Isla y su maravillosa gente pueden ofrecerles.
I'm told that we would have only problem at the podium here. Do you on the floor hear channels 4, 5, 6, and 7? Yeah, German was okay. Sure. Les autres? Okay. It seems that we have a problem at the podium here. Could you go to Mr. Grabenbart? He wants to tell something.
C'est bon?
Le problème, c'est juste ici. Dans la salle, ils entendent bien. Mais nous, ici, on a un problème. Nos appareils ne fonctionnent pas.
Alors, il faut changer les appareils, non?
Oui, c'est ce qu'ils ont déjà fait. Il semble qu'il y a des interférences de quelque chose qui sont locales. I just heard very scrambled number 4. 5 is okay. 5 is okay now. Русский канал 6 работает. Хорошо, спасибо. Иси. And 7 works. It seems that the problems are fixed. Some, no, not yet.
C'est bon? Mhm. Pas encore. Hein?
Ils ont enlevé l'appareil de Madame Tanasescu. Maintenant, ils lui donnent un nouveau. Une fois quand on a ça, c'est bon et on peut commencer. Excusez-moi. Je suis désolé. Je dois quand même comprendre ce que vous dites.
Oui, justement. C'est bon.
si... Oui, donc juste pour que vous prenez canal 1. Donc si le canal 1 peut juste... Works, vous entendez 1? Ok, everything is fine. Merci beaucoup. Veuillez excuser ce délai. Il semble que ça fonctionne maintenant. Merci.
On commence? C'est bon? بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين السيد رئيس المحكمة الدستورية السادة أعضاء المحاكم الدستورية والمجالس الدستورية للمؤتمر الخامس.
Delegasi yang terhormat,
السلام عليكم جميعا ورحمة الله تعالى وبركاته. قبل أن أبدأ أود أن حني أمام أرواح الذين سقطوا جراء التدافع الذي وقع يوم الأحد الماضي، وأقدم باسمي والوفد المرافق لي تعازينا الخالصة لأسر الضحايا، وأعبر عن تضامننا مع السلطات والشعب الأندونيسي في هذه المحنة. إنه لمن دواعي الغبطة والسرور أن تكون الجزائر أول رئيس لأول جلسة لهذا الحدث القضائي الدستوري العالمي الخامس، الذي تتشرف أندونيسيا باحتضانه بكل جدارة واقتدار. وأغتنم هذه السانحة لأقدم خالص شكري وعظيم امتناني للسلطات والشعب الأندونيسي ولأخي السيد أنور عثمان رئيس المحكمة الدستورية وقضاتها وجميع العاملين بها على حفاوة الاستقبال وكرم الضيافة والتدبير المحكم والتنظيم الجيد لمؤتمرنا هذا، والذي سيكون ولا شك ناجحاً بكل المقاييس. وأغتنم هذه الفرصة لأبلغكم تحيات السيد عبد المجيد تبون رئيس الجمهورية الجزائرية وتمنياته بالنجاح لأشغالكم، والذي يثمن عالياً الدور الذي تلعبه العدالة الدستورية في ازدهار الأمم من خلال إحلال العدل وحماية الحقوق والحريات، وهو ما حرص على تجسيده شخصياً من خلال مبادرته المتضمنة التعديل الدستوري الذي زكاه الشعب الجزائري مؤخراً في استفتاء أول نوفمبر 2020. اختار مؤتمرنا هذا موضوع العدالة الدستورية
the subject of
وموضوع يكتسي أهمية قصوى بالنظر إلى كون العدالة هي إحدى ركائز التماسك الاجتماعي، من حيث إنها تعمل كوسيط في النزاعات بين الأفراد، وكذلك
that works as a mediator of disputes between people and an institution. Therefore, the intermediate justice should be neutral so that it has credibility and it is appreciated. Peace that is meant here is not the classical concept of peace that we know in the international law, which belongs to the solution of disputes among states. This concept is not part of the constitutional justice, but it is considered to be peace, peace within the country itself, and among the categories of the one nation. It is first of all the social peace that we all asking and all the people are requiring. Disputes are usually emitting from conflicts, political conflicts, which makes it very difficult to solve. On the other hand, the constitutional justice can contribute positively through his interpretation to the provisions of the Constitution to mitigate the impacts of conflicts and to limit these conflicts and to calm down the political arena through the smart solution within the constitutional system. Therefore, this conference is obliged to reach a comprehensive agreement through the experiment that has encountered our constitutional court, and also to know the legal mechanism and the case law that has been resorted to encounter this problem. It is also dependent what we have in our constitutions regarding provisions that relates to the subject of peace and reconciliation, which we will view part of through some of the answers of the surveys that has been pasted without. It is worthy for me to mention here in the first session of this conference that is the resources and the jurisdiction of the constitutional courts. What I mean is to know whether the matter or the subject of peace and reconciliation are part and parcel of constitutional courts and councils, or is it the constitution that has stipulated, openly stated peace or reconciliation in the provisions? If it is so, this is considered to be a reference and a source that we shall rely on the constitutional courts whenever it is required to interpret.
منها شريكا مفضلا يساهم في استتباب السلم الاجتماعي وفي تنظيم واستقرار الحياة السياسية من خلال الاجتهاد الذي يصدر عنها ولاعبا فاعلا في نشر الطمأنينة وإرساء السلام. وللتعمق في هذا الموضوع يحضر معي السيد الفاضل والسيدات الفضليات السيد أنور عثمان رئيس المحكمة الدستورية في أندونيسيا وهو المتحدث الرئيسي، والسيدة سيمينا تونوسيسكي قاضية بالمحكمة الدستورية لرومانيا وهي مناقشة، والسيدة جوانا فرنانديز كوستا قاضية بالمحكمة الدستورية البرتغالية وهي مقررة. وقبل أن أحيل الكلمة للمتحدث الرئيسي سعادة المستشار السيد أنور عثمان، أذكر ببعض المحطات من مساره المهني. فهو حاصل على بكالوريوس قانون من الجامعة الإسلامية بجاكرتا عام 1984، حاصل على ماجستير في القانون 2001، حاصل على دكتوراه في الدراسات السياسية جامعة بوجيا كارتا سنة 2010. أصبح أستاذاً فخرياً في جامعة سلطان جونج سيمارانج سنة 2022. عمل مدرساً ومارس القضاء في العديد من المحاكم الأندونيسية إلى غاية 1997، ثم كاتب قاضي بالمحكمة الإندونيسية العليا سنة 1998. عين قاضياً ورئيس مكتب الموارد البشرية بالمحكمة العليا عام 2005.
In the High Court in 2005, and also the chief of the training section in the High Court of Indonesia. He was part of the Constitutional Court of Indonesia in 2011. He was vice chief of the court in 2015 until 2017. He's currently the sixth president of the Constitutional Court of Indonesia since April 2018. He is hosting us today on the occasion of this conference. I would like to remind you that if the president's task is very clear, which is to act on this session, the keynote speaker will give us some summary of the survey, and he has 20 minutes to do that. The conversation and discussion will respond to the keynote speaker, and she has 10 minutes. The rapporteur will write down the notes and will present and table a report about this session to the concluding session. I would like everyone to abide by the time limit. Mr. President, you have 20 minutes to give a brief synopsis of the answers that has been listed in the question, listed in the survey.
Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk
Greetings and may peace be upon you.
yang saya muliakan.
Good tidings to us all.
Special Representative Venice Commission.
The special representative of the Venice Commission, Mr. Gianni Wccj, and the Secretary General of the Venice Commission, Mr. Snitz-Dur, distinguished President of the Constitutional Court, Constitutional Councils and equivalent
Honorable
institutions.
Chair of the Constitutional Court and other courts.
Dear member countries of the AACC, participants of the 5th Congress of the Wccj, ladies and gentlemen, first of all, allow me to welcome you to this beautiful island of Bali, one island full of charm, island of the gods, island that has been the tourist destination of so many visitors from so many countries. Hopefully, with the organization of the 5th Congress, no, we're not using the console.
Dan bertukar pengalaman terkait tema yang sudah disepakati.
Testing, 1, 2, 3. Testing, 1, 2, 3. Testing, 1, 2, 3. Testing, 1, 2, 3. English channel, check. Check sound, English channel. Testing, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Check sound, check sound, check sound. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Check sound. English channel. 1, 2, 3, 4, 5, 6. I think they're trying to fix it. I'm not.
Mas Heru. Saya ulangi. Mohon petugas supaya memperhatikan audionya. Pada kesempatan kongres ini, kita akan saling berbagi dan bertukar pengalaman terkait tema yang sudah disepakati, yaitu tentang perdamaian.
Regarding the predetermined theme, especially for the sub-theme this morning, we will talk about the source of law and jurisdiction of constitutional courts, which would be an important tool to realize justice and peace. And that is why this forum would be one of importance for us, because it allows us to talk about constitutional application in every countries, as well as the role of judicial bodies to realize justice and peace in our respective countries. Ladies and gentlemen, for the Indonesian nation, peace and justice is at the heart of our life as a nation and in our statehood. And that is why explicitly and implicitly the Indonesian Constitution is imbued with a spirit of justice and peace. And that is clearly apparent in the first line of the opening that says, therefore, that independence is the right of all nations. And I can repeat, whereas independence is the right of all nations. And therefore, colonialism must be abolished as it does not conform with humanity and justice. Based on that sentence, it is clear that the Indonesian Constitution declares its disapproval of colonialism because independence is the right of every nation. This disapproval of colonialism means that the Indonesian Constitution holds fast to the principle of peace and asserts that if colonialism occurs, then that is something that goes against to the principles of humanity and justice. For that reason, the Indonesian Constitution, as our fundamental law of the state, can be concluded that it is inspired or based on the principles of peace and justice. Therefore, our founding law has provided us with sound legal basis to realize peace and justice, not only for our Indonesian nationals, but to actively contribute to world peace for the realization of independence, lasting peace, and social justice. Ladies and gentlemen, in the concept of rule of law, there's no exercise of state powers or official powers that is not based on legislation. And that is why, according to the mandate given by the 1945 Constitution, then the Indonesian Constitutional Court has the task to marshal so that the values found and enshrined in the Constitution are applied and implemented in our lives as a nation. In regards to that, there are two issues related to our discussion, just the examination of laws on the ratification of the Association of Southeast Asian Nations, ratified through Law Number 38 of 2008, and law on the ratification of foreign or international treaties. In the law on the ratification of the Charter of the Association of Southeast Asian Nations, there were two issues examined. The first was whether the Indonesian Constitutional Court has the authority to examine a legislative product which material is the result of ratification as regulated in the international agreements. Two, if the Constitutional Court has the authority, then the next question is whether the Constitutional Court has the power to review substantively the outcomes and the contents of international treaties. On those two questions, the Constitutional Court has rejected the petition of the petitioners, and Constitutional Court also declares that it does have authority to examine a ratifying law. In a different case, in a case of the judicial review of Law Number 24 of 2000, there were a few legal questions submitted by the petitioners. In their examination, the Constitutional Court has accepted their petition in part. Ladies and gentlemen, world peace and justice, or peace and justice in one country, can only be realized if the fulfillment of the constitutional rights of individuals and the protection of human rights can be done optimally, and the mutual respect of sovereignty can also be exercised in balance. Based on those two cases, the powers of the Constitutional Court in protecting constitutional rights of citizens has become of importance. Without the protection and fulfillment of citizens' constitutional rights, it would be impossible for us to realize a just life. And without a just life, it would be impossible for peace to be realized, both for the continuation of the state and for one nation as well as for other nations as well. To conclude, I would like to thank you for the opportunity and honor given to the Constitutional Court of Indonesia to host the 5th WCCJ Congress, one that is an honorable forum. Hopefully, the collaboration and cooperation established between nations, between constitutional courts and equivalent institutions can continue to be strengthened in the future. Again, thank you and apologies for any mistakes and shortcomings. Greetings and may peace be upon you.
I would like to thank in your behalf His Excellency Anwar Usman, the head of the Constitutional Court in Indonesia, in his capacity as the keynote speaker of this session, for his invaluable intervention and the summary that he has provided us with, which allows us to have a clear image and comprehensive one about the provisions of constitutions on peace and reconciliation and the jurisdiction of constitutional courts in that field. Also, the role of the judge in interpretation of these related provisions in this interpretation. We have seen also that constitutional courts and council can be a stability factor that we cannot do without to protect human rights, that it is part and parcel of the process of solving disputes and providing peace. Also, I would like to appreciate the introduction that Anwar Osman has given regarding the position of peace and the value of peace in Indonesia. It is very important for the Indonesian nation, part and parcel of the Indonesian constitution for the principles of peace and justice. Where the word Mardika, which means peace, it has been repeated 7 times in the preamble of the Constitution of Indonesia, and which also was the disapproval of colonialism, which is the contrary of international justice. The colonization is the enemy of justice and the enemy of peace. I would like to thank you very much, Mr. President. I'll give the floor now to the second speaker, Her Excellency, Her Excellency Semina Tunisisko, to run the discussion and for the speaker, the keynote speaker. She has 10 minutes. Please go ahead. One thing. Before that, I would like to that Her Excellency Ximena Tionisisco is a judge in the Constitutional Court of Romania since 2019. She has BA in law from Bucharest University in 1991 and diploma in common law and PhD in common law in the School of Arts and from Marseille University, France, in 1997. And after doctorate studies in the Constitutional Court from the University of Bucharest, diploma in Paris University. She is a founder of the Constitutional Center of the University of Bucharest. From 2008 to 2019, a representative of the Supreme Council of Judiciary from 2009 until 2011. The representative of Romania in the European Union from 2000 until 2004, a member representing Romania in the panel of independent experts for the local and regional municipality in the Council of Europe in 2018. She is a presidential consultant between the years 2015-2018. She has lots of books, and she has some published studies and articles in specialized magazines. She has a number of awards She has been appointed in the Constitutional Court in Romania by the Romanian president in 2019 for 9 years. Please go ahead.
Chairperson, Honorable President of the Court of Indonesia, distinguished guests, ladies and gentlemen. Allow me to thank the organizers of the 5th Congress of the World Conference on Constitutional Justice for inviting me to address such eminent participants, and particularly for having the honor to follow up the keynote speech of the Honorable Anwar Usman, Chief Justice of the Constitutional Court of Indonesia, our distinguished host. The topic of this World Conference is timely and appropriate. Debating on constitutional justice and peace means exploring the role of constitutional courts as actors of conflict resolution and addressing what has nowadays become one of the arduous issues of numerous democracies all across the globe, namely societal cleavage and political polarization. This is not to say that one has to forget the vital meaning that the legal concept of peace has in international public law, particularly under the current circumstances. But peace within the state remains the realm of constitutional courts, and the World Conference on Constitutional Justice stays put with its sphere of activity. Viewed as an affliction to social peace, cleavage and polarization are not new, but they have intensified over the past years, up to the point where each side in any given society perceives the other no longer as an alternative or diverse version of itself, but rather as a danger. Pluralism tends to succumb, and democracy is threatened. In such circumstances, a third, impartial actor becomes necessary in order to mediate peace, and this can only emphasize the important role that constitutional jurisdictions play in contemporary societies. The first panel of this World Congress on Constitutional Justice is dedicated to sources and jurisdiction. The questionnaire addressed to all member courts asked them to identify explicit references to peace in their respective constitutions and constitutional provisions that implicitly may cause problems for social peace, as well as to explain the way in which constitutional courts have interpreted the concept of peace and the mandate explicitly granted or implicitly assumed by the constitutional jurisdiction to maintain peace. Let us attempt to discuss the wealth of ideas included in the general report presented in this section and scrutinize them through the lenses launched in the keynote speech. Honorable ladies and gentlemen, the keynote address is focused on the multiple interpretations that the concept of peace may acquire in constitutional texts. It underlines that peace and justice are the spirit and the heart of any modern democracy, and it eloquently presents the constitutional framework of Indonesia, which includes explicit references to the concept of peace no less than 7 times in the preamble of its fundamental law. In an attempt to synthesize the rich and fertile answers received from member courts, the keynote speech focuses on the universal dimension of the concept of peace, considered as a plainly harmonious concept. This approach is expressively depicted in the concept of civic harmony, used in the preamble of the Ukrainian constitution. Under this broad umbrella, various nuances may be distinguished. Thus, some constitutions seek to protect the concept of peace by simply rejecting war as an instrument of aggression against the freedom of other peoples. Let me give a normative example. Article 11 of the Italian Constitution refuses war as an instrument for the settlement of disputes. Let me give another example, normative and jurisprudential. Article 5 of the Korean Constitution obliges the state to maintain international peace and renounce all aggressive wars, which allowed the Constitutional Court of Korea to interpret it as imposing a fully fledged obligation on the state to maintain peace and not fight war of aggression. Some other constitutions take into account peace as the main vocation of their state and consider it under the angle of universal harmony that has to be actively promoted. The Constitution of Burkina Faso, for instance, desires to protect peace, while the Constitution of Cambodia values the peaceful coexistence with neighboring countries. In Europe, several constitutions declare their intent to participate in various forms of international cooperation in order to protect peace and human rights. And I list here only a few, and I'm certainly forgetting others: Estonia, Finland, France, or Germany. Most often, constitutions consider peace as a major goal of their community of people, reunited within the states. To take only a few examples, in Côte d'Ivoire, the preamble of the constitution mentions the building of a peaceful nation and the strengthening of national reconciliation, while the preamble of the Kazakh constitution proclaims the people of Kazakhstan to be a peace-loving and civil society. Alike, the Constitution of Thailand declares peace and reconciliation the common good of the nation and the happiness of the public at large. Other constitutions may refer to peace within a state that intends to heal previous divisions and reconcile after armed conflicts. Such is the case of Bosnia and Herzegovina, where the Dayton Agreement, still a fundamental law of the land to this day, clearly spell out that the constitution is dedicated to peace, justice, tolerance, and reconciliation. Also, the Rwandan constitution includes a preamble that declares peace, unity, and reconciliation as pillars for development. And even the constitutions which already include provisions obliging the state to heal wounds of past internal conflicts, revisions of those constitutions continue to stress the idea of peace. Such is the Constitution of South Sudan, which already referred to a peaceful and prosperous society, and which is now complemented by the revitalized agreement on the resolution of the conflict in the Republic of South Sudan. Or, for instance, in Macedonia, following the internal armed conflict of 2001, a revision of the constitution now explicitly mentions a political agreement, the Ohrid Framework Agreement, viewed as a first step towards the reconciliation of the parties in that conflict. Or some other constitutions envisage the concept of peace from the perspective of social cohesion and the prevention of social conflicts. The Dominican constitution mentions peace as a fundamental principle for social cohesion. The Swiss constitution refers to peace in labor relations and religious communities. Article 3 of the German constitution, or Article 10 of the Spanish one, they cite social peace with the meaning of social cohesion, as it has amply explained by their respective constitutional courts. And Article 48 of the Constitution of Togo spells out social order, peace, and national cohesion as the main goal of the fundamental law. Of course, many other nuances may be distinguished in the national reports, such as the civic peace mentioned in the Moldovan constitution, or the peaceful political activity in the Namibian one, or the obligation made to the Canadian Parliament to make laws for peace, order, and good government. On the other hand, at times, peace within the state may prove to be a difficult objective precisely due to the less than clear constitutional or legal provisions. There are societal cleavages and conflicts in nowadays democratic societies that are rooted in constitutional provisions. Some of these problematic stipulations tend to give expression to issues predating the adoption of those constitutions, such as institutional arrangements meant to preserve political equilibrium. The keynote speech addresses all these issues when stating that there is nothing in the exercise of the authority of state institutions or a policy or an action of state officials which is not based on the statutory provisions. This is the context in which the role of constitutional courts as mediators becomes crucial. When interpreting such constitutional provisions, courts have to bear in mind that one of their main functions is conflict resolution. This includes, as we read in the Lithuanian report, a constitutional interpretation that allows for a harmonious legal system without any gaps or internal contradictions. Or, as the Lithuanian Constitutional Court put it, the constitutional interpretation has to be performed in a manner that does not distort or deny any provision of the Constitution, and which does not disrupt the necessary balance among constitutional values. And yet some other constitutional provisions exist simply because they express the nation's or the state history. In some cases, stock is taken by the constituent power and conciliatory clauses are added in order to accommodate past and future in one text. To take just one example, the plurality of sources mentioned in numerous national reports, and again, I'm certainly forgetting some, Denmark, Gabon, Kosovo, Sao Tome and Principe, and so on, it succeeds in mixing domestic sources with international ones in order to promote peace as a global concept. To take another example, in Eastern Europe, accession to the European Union has led to constitutional revisions which promoted the primacy of EU law over national law and planted the seeds of a plurality of sources, both with regard to social cohesion and concerning the collective engagement to promote specific common values as peace and rule of law. Distinguished guests, the keynote speech also emphasizes the concept of the state governed by the rule of law, and it highlights that the remit of the Constitutional Court of Indonesia is to maintain the constitutionality of the state. The jurisdiction of constitutional and supreme courts is therefore essential, not only when interpreting the constitutional provisions referring explicitly to peace, but also when accomplishing their most ordinary tasks, such as reviewing the constitutionality of laws, resolving conflicts of jurisdictions between public authorities, or settling electoral disputes. To give just one example, in Romania, where I come from, the Constitutional Court has the specific constitutional task of solving legal conflicts of constitutional nature between public authorities. In fact, like any other type of court, constitutional jurisdictions are instruments of conflict resolution. They bring peace through reasoned arguments, and they appease the state authorities and political actors while constantly mediating between state power and civil society. As the Angolan National Report suggestively states, contributing to social peace is the specific mission of all courts, and particularly of constitutional ones, or as the Finnish Supreme Administrative Court stated, although it does not have a specific mandate, it considers maintaining peace as a crucial element. However, some constitutional courts do enjoy an explicit mandate to guard and promote peace within the state. This is the case of the Constitutional Court of Belgium with regard to social peace between linguistic communities, or the case of the Constitutional Court of Benin with regard to social peace, protection of fundamental rights, and functioning of public authorities. On the other hand, even if they do not have a clear mandate, constitutional courts do provide solutions to issues that otherwise could have developed into conflicts. The concept of social peace has been instrumental for some constitutional jurisdictions, which sometimes simply assumed a role in conflict resolution, such as the state of the Constitutional Court of Brazil, which frequently finds legal or even constitutional provisions that conflict with the maintenance of social peace, or the case of the Constitutional Court of Ukraine, with its resonance cases, namely those dealing with the conviction of totalitarian political regimes or with the prevention of corruption. Finally, national reports also illustrate a relatively large range of interpretations of the concept of peace, and at times this task has been accomplished not solely by the constitutional jurisdictions, but also with the support of traditional forms of justice, as some reports clearly point out. In this respect, there is also a large variety of possibilities. Reports drafted by the representatives of Cameroon, Canada, Cyprus, the Dominican Republic, Egypt, Estonia, Finland, Indonesia, Mexico, and again, I'm certainly forgetting others, declared that traditional justice or aboriginal laws and practices may be useful for conflict resolution, including at constitutional level. Distinguished participants, the keynote speech ends on a positive and constructive note when advocating that justice and peace may only be realized if fundamental rights are optimally secured. The ultimate goal of constitutional jurisdictions when rendering justice in order to achieve social peace is the protection of fundamental rights. And that is a thought that we have to cherish and preserve. Thank you for your attention.
شكرا للسيدة تيمين تونو سيسكو على مداخلتها القيمة والتي طافت بنا بين مختلف الدساتير مبينة الاختلاف الواضح في تناولها لمفهوم السلام ومقاربة كل.
I would like to thank her for the perspectives of the various countries concerning the concept of peace. She has also responded to the various questions and has offered us various scenarios concerning the protection of human rights and democracy, as well as the rule of law, which is a prerequisite for peace. Once again, I'd like to thank Madam Seminar for her presentation. Might I remind you that Ms. Joana Fernandes Costa is also amongst us. She has a bachelor's degree from the University of Coimbra in law, and she also has a master's in criminal law from the University of Lisbon in 2013. She became a judge in 1996 and served at the criminal courts of a number of judicial districts, especially and at the Court of Lisbon. She served as assistant to the officers of the Vice President and the then President of the Constitutional Court between 2006 and 2015. Currently, she is member of the editorial board of the journal called Julgar, and she is appointed to the Constitutional Court of Justice by the Assembly of the Republic since July 2016. Ms. Joanna is our rapporteur for this session, and she will be presenting her report during the closing session. I would like to thank her for the effort she has put in preparing a detailed report for the closing session, which will be tomorrow. And now, I'd like to give the floor to the Assembly for question and answers for a period of 30 minutes. So whoever would like to ask a question, you can raise your hand and ask your question. The floor is open. I'd like to ask you to first introduce yourself, the court you represent, etc.
Okay, thank you very much, Mr. Chairman. My name is Dewagede Palguna. I'm a lecturer at the Faculty of Law at Udayana University and former Justice of the Constitutional Court of the Republic of Indonesia from 2015 until 2020. I would like to, sharing experience maybe from Her Excellency Justice Tanasescu. I think to our experience in Indonesia, the most serious struggle for constitutional justice, especially for countries which had been years under authoritarian or even oppressive regime, is how to build an adequate culture necessary to achieve those goals of constitutional justice itself. Maybe Justice Tanasescu would like to share the strategies to address the issue. Thank you very much.
Thank you very much for your question. As you know, my role here is as a discussant, so I'm supposed to raise issues and problems of concern which have been already addressed in the keynote speech. Indeed, and I have been through the general report which was drafted by my colleague, Justice Costa from Portugal. But in the national reports that I have perused, like everybody else in this panel, there's a limited number of there are a limited number of reports that actually deal with this issue. However, I could notice that the Ukrainian Constitutional Court has been faced with what they call resonance cases. And they have mentioned that they are in the process of condemning authoritarian regimes, which definitely in Ukraine must refer to the past regime, to the recent past, I would say. And they tend to say that they compare the current situation under the current constitution with what has been in the past. And those aspects which come from the past, they pass them through the filter of the present constitution. As I said in my discussant report, there are situations where the constitutions which were recently adopted, they have to reconcile within one text both the past and the present. And the general technique may be to look at the past with the lenses of the current values which are settled in the new constitution. I don't know whether this, I mean, I have taken the Ukrainian example because it referred specifically to authoritarian regimes. I'm sure that there must be other solutions as well, but that was one of the solutions that was literally provided in a national report. I don't know if this answers your question or not. Thank you.
سؤال تاني؟ في سؤال؟
Any further questions? Any further questions from the floor? If there aren't any further questions, we shall close this session. Oh, sorry, I do apologize. There's a question, someone's hand that has been raised.
Ah, là. Microphone is coming.
Thank you very much, Mr. Chairman. Straight forward to the elaborations of the source related to your points. The customary laws also could be a strategic resource as a constitutional valid values. But if we look at the situations in plural legal systems, like Indonesia, for example, consists of 18 regions of customary laws and more than 366 clans that have shores or ethnic customary laws. If you talk about the potentials of customary laws as a source of valid norms, yeah, related to the constitutional intercourse in Indonesia, for example, how come to create or to ascertain the legal certainty, yeah, in accommodating all of the plural customary laws in Indonesia? Could you elaborate this, Her Excellencies? Thank you.
شكرا. تفضل.
Testing, can you hear me?
Baik.
English channel.
Terima kasih atas pertanyaan Bapak. Sebagaimana kita ketahui bahwa di Indonesia adat dan hukum adat itu diakui dalam konstitusi kita. Oleh sebab itu hukum adat.
So the question is, which indigenous or customary law that prevails in Indonesia, given that we are a nation of approximately 360 ethnicities, different languages and ethnicities. And so each ethnic group will have their indigenous laws, but it shouldn't be in conflict with national law. And so that is the main principle. And indeed, in the past, we had something called the Swapraja court or the customary court. And we also see that the products of these customary courts in the past, especially ever since Indonesia's independence in 1945, has been adopted or merged into our national law. So given that they are not in conflict with our national law. So that is the response that I have now. Thank you.
شكرا سيادة الرئيس. تفضل. عندك جواب؟ نعم. تفضلي.
Thank you. Just to emphasize what has been written in the national reports as well, which is exactly what the Honorable Anwar Usman, Chief Justice of the Constitutional Court of Indonesia, has mentioned. In other national reports as well, it is particularly the contractual matters and the statutes of persons that are settled according to traditional justice rules. And these matters often include a national human rights dimension. For instance, in Cameroon, judgments delivered by customary courts on the statutes of persons are binding. And in Canada, oral evidence describing past occupation of Aboriginal land is legal proof considered valid by the state courts, despite the written procedural rule contrary to the hearsay. But everywhere where this has been the case, the customs or the traditional law to be used in order to solve conflicts It may be used as long as it does not contradict the written constitutional law, as it has been clearly underlined here by our host, and the same is valid in Denmark, Georgia, or Korea, or anywhere else where this has been done. Thank you very much.
Thank you, Mr. President. I would have two questions, both to the Chief Justice and to Justice Tănăsescu. The second one is linked to what we just discussed, but the other one is more general. And it was Professor Tănăsescu who cited the keynote speech from Chief Justice Usman when you said we have to bear in mind that one of the main functions of the constitutional court is conflict resolution. That was really the key issue which I found in both the keynote speech and the discuss and reply. And I wonder how the fact whether the Constitution itself refers already to this task of conflict resolution, to the necessity to provide peace, or not, whether this has a direct influence on what the Constitutional Court can do. To which extent is there an open interpretation of the Constitution more conducive to the possibility to settle conflict than an interpretation which is rather literal and only takes into account what the Constitution says? So we have in some countries we have these originalist interpretations which are very strict and very rigid and follow only the letter of the law. Are courts which have a wider understanding of the Constitution and use a purposive or a teleological interpretation, is it easier for those courts to settle conflicts and to achieve peace? And then a very short second question, also to both justices, as the first question related to Aboriginal laws. Do you see a difference as concerns the task of the Constitution if we have a system like in Indonesia, where you have many nationalities, but they have the same rank? Whereas in other countries, you may have a majority and defined minorities. Is there a structural difference in the interpretation by the Constitutional Court how to achieve peace? In view of the question whether this relationship is a horizontal one or a hierarchical one, if we can say so, hierarchical between the majority and the minority. Does this make a difference in how the Constitutional Court can go about achieving peace? Thank you. These are my two questions.
Thank you very much for both questions, actually. I'm not sure if I'm the most well-positioned to answer the second one, but I'll do my best to do it from a theoretical point of view. But to the first question, I may give you the... as I said, there are constitutions which make specific the mandate of constitutional courts in solving conflict resolutions. There are those which do not mention it. For instance, the German Constitutional Court measures every application of the law and every administrative decision against the standards of the Constitution in order to ensure the social peace. So even if it does not have a specific mandate, it does it on a constant basis. The same happens, for instance, in Serbia, where the Constitutional Court has helped a lot in reducing social and political frictions by making prevailing the protection of fundamental rights whenever solving electoral disputes. I personally believe that a rather wider interpretation, a rather open interpretation, and not necessarily a very strict or originalist one, is helpful in dealing with conflict resolution, and it may allow for an easier path to be taken. But I'm not sure that that might be the approach of every other court. As to the second question, referring to the horizontal or the vertical approach with regard to conflict resolution, I think that, again, irrespective of how the community of people is constituted, I think that what has to remain in mind and what is the most important issue for any constitutional court is the protection of fundamental rights. And if we take into account the values that are relevant for that constitution, you may easily find normative solutions for solving that out. Again, prevalence of fundamental rights, primacy of the constitution should help a lot in dealing with such issues. I don't know if they totally solve the problems, but at least they help us. Thank you very much.
Ya, baik. Secara singkat, pada prinsipnya pengadilan.
So, around the world, including in Indonesia, the principle of judicial passiveness, or where judges are waiting for reports from our members of the public. And in the Indonesian Constitutional Court, we have presided or ruled over in acknowledgement of the existence of indigenous rights and indigenous communities, and that they do have legal standing to request a review, a judicial review of the law and legislations to the Constitutional Court. So that is my explanation. Thank you.
Questions?
Buka aja Pak, biar jelas.
Okay, must be open. The mouth is. I just want to know if you have experience. My question is for Ms. Saminata Skaku. In a state which have two model of courts, Supreme Court and Constitutional Court, whether the decision of Constitutional Court must be applied by the Supreme Court, or are there any conflict between the two system of courts, if you have this experience about it? Thank you.
Thank you very much for your question. I don't think that we had such a situation in the national reports that I have been perusing. However, there are numerous countries that have indeed Supreme Courts at the top of their judicial system and constitutional courts separate from the regular judicial system. And I think it is the case that in such situations, we talk about the judicial dialogue, which is another topic in itself, a distinct one. Indeed, the constitutional courts, they render decisions and rulings that are generally binding, and it would be expected that any other subject of law, be it a citizen or a public authority, should go along, should comply with the decisions or the rulings of a constitutional court. I think it, from the remit of their jurisdiction, because they have to render general decisions that may even invalidate laws, their rulings should be fully respected. Whereas the Supreme Court they only refer to specific cases. However, at the same time, I have to say, there are plenty of systems where the two kinds of jurisdictions are united in one and the same, and that is the Supreme Court of the land, which also may provide for judicial review, and in those cases, even that decision refers to the specific case at hand. But this doesn't make that decision less compulsory. On the contrary, I would say it definitely has to be also respected by all the other public authorities and justices. However, again, the national reports did not provide information on this specific item that you were mentioning. Thank you.
Well, when the Constitutional Court decides something that it was unconstitutional, but 2 days after this decision, the Supreme Court judges say again that decision. We will not be applied the decision of the Constitutional Court. It has happened in your experience, or you gave information about this kind of conflict, quote-unquote conflict between the two jurisdictions. It is Indonesian experience, so I will share with the other experience with the other states, with the two jurisdiction of courts.
As I said, it may be the case. It was just that the questionnaire that was sent did not address this type of conflict. But I'm sure that it may exist. Simply, I am not aware of it because it was not meant in the questionnaire, so I haven't received it. If you can send that issue to me, it would be very nice. Thank you a lot.
Please take the floor and mention your name and which constitutional court you belong to or equivalent body. You have the floor.
Bon. Je suis Mohamed Sherif So.
I'm Mohamed Sherif So, member of the Supreme Court of Conakry, Guinea. And my question is to Simina Tănășescu. Constitutional courts play an important role in maintaining peace, but they cannot act on their own initiative. They are limited to being requested to act on a specific matter. And usually the conflicts that occur in countries are of the competence of other constitutional courts. So what kind of role, can these constitutional courts use to maintain peace? Can they serve that role, really? That is my question.
Merci beaucoup pour votre question.
Thank you very much for your question. Yes, that is indeed one of the questions that was part of the questionnaire, and it was dealt with under the angle of the competence of the constitutional courts. Constitutional courts generally act once they have been, a matter has been brought to their attention, but the other kind of acting is rare. But they address themselves not only to the procedure, simply to the resolution of conflicts and the maintenance of peace within a country, political peace also, and cultural peace. The immediate response would be too simplifying. We would say, no, it's not possible that other groups do handle matters to the court. But since I've seen it in the reports, there are constitutional courts which, via their attributions, their usual attributions, can already been asked to deal by the authorities that have a right to do so and have, in fact, have been approved the fact that they were not and have dealt with the general situation. So it is rather rare that in such kind of situation that the constitutional courts deal statutorily with peace as a matter of their role. But those who have submitted the report said that the mere fact of carrying out their usual attributions has already contributed to social peace. I hope that this helps in responding to your question.
Excusez-moi d'intervenir encore une fois.
Sorry to intervene once again, because the Constitutional Court dealt with this matter in a report. And in order for the Constitutional Court to be able to play its role to guarantee and to facilitate peace in a country, it must be able to decide. I think that's what you are referring to. It is maybe the fact that a Constitutional Court is ready to deal with the matter, but if it doesn't have the role, it cannot do so. Can anybody prevent it from playing that role? The only problem is that what is the solution? Would it be a simple seizure of the court? In that court, it could be considered as a political act that the court is seized of a matter of a problem that exists in the country. But one can also solve the same problem by widening the possibilities of seizing a constitutional court of a country, for instance, for it to be not only a majority, but also a minority of members of parliament that do so. In other words, the opposition also. It is particularly on this that the courts deal, so that it is possible even for an individual to address a constitutional court. And would this mean automatically that the court could actually be seized of a matter? But the problem that is faced with a problem that it wants to deal with, but it can't do so because its role doesn't allow it. Would it be possible to allow it to do so, to deal, so as to help to contribute to the solution of the problem? In other words, a widening of the seizure in general would avoid the problem to resort to a different type of seizure, which could be viewed as a political interference. Thank you.
Merci.
Thank you.
Any other question? Do you have any other question? Go ahead.
تفضل. Yeah, just a minute.
Merci. Alors,
Thank you. I'm Jacques Lebama. I am a judge at the Constitutional Court in Gabon, and I'm representing the president of the court, Madame Madeleine Barbour. So I am the head of a delegation of the constitutional judges of the Court of Gabon. And before dealing with the matter, I would like to congratulate the speakers who have illustrated the matters very clearly and have educated us. I have two questions. Firstly, my comment rather is, firstly, the type of conflicts of competences between constitutional jurisdictions and constitutional courts. But if I deal with the example of Gabon, in Gabon, the constitution is clear. It states clearly that decisions of the Constitutional Court are compulsory for all jurisdictions of the country and also compulsory for all civil and moral persons. Even if when we don't have a Supreme Court in Gabon, but we have a Cour de Cassation and a state court, a Cour d'État, but each one has its own corridor, so there is no major problem there. But the Constitution, from our point of view, is, so to speak, the spine of the whole legal system. And the spine must be well maintained, must be cared for by those whose responsibility is to take care of this spine. In other words, the constitutional judges. In this regard, in our Constitution, the Constitutional Court is the regulating body of the Constitution and of the activities of public bodies. And while it is acting on its own roles, when it is being seized of a matter, the Constitutional Court, with a view to entertaining peace, maintaining peace, can sometimes make useful comments. And that is as a result of the basic law of our Constitutional Court. So sometimes, seeing that it might be seized, can make comments where the court deals that they are useful. So I just wanted to make that contribution to report on our own experience. Thank you.
Yes, there's another question.
Saya Galang Asmara dari
My name is Galang Asmara from Indonesia.
Yes.
Go ahead, sir.
Okay. Yeah.
Thank you very much, Your Honor. I would like to also bring up once again the issue of indigenous law. In Indonesian legal system, it is stated that indigenous law is recognized by our constitution. In the constitution, it states that the constitution is the prevailing law and that local, traditional, and indigenous laws should not be in conflict with our constitution. In practice, however, the indigenous law isn't the implementer of our constitution, but is also something that grows and develops among society. And so in theory, it might be possible that one day there will be developments in which the indigenous law will come to be in conflict with the Constitution. And in this case, who has the authority to review these laws? In the Indonesian system, the Constitutional Court has the authority to review legislations or laws against the Constitution. But what about the traditional and indigenous law? So that is my question to Your Honor Chief Justice of the Constitutional Court of Indonesia, and also to other speakers. If you have ever encountered such case, who has the authority to review indigenous laws? Is it a constitutional court or an equivalent institution? That is my question. Thank you.
Thank you. Thank you. This is the last question.
Yes, thank you for your question. Let me begin also by responding to the comment from our delegate from Gabon regarding the authority of our constitutional court. Indonesian constitutional court has four authorities. One is to review legislations against constitution. Second is to decide or rule disputes between and among state agencies and authorities. And one of the authorities of Indonesian Constitutional Court is to rule or decide and settle disputes among state agencies and authorities. And also, we have the authority to ban and to dissolve political parties, and the authority to also resolve election disputes. And also regarding the impeachment based on violations committed by the president and the vice president. So in Indonesia, the dispute among state agencies, for instance, between the office of the president and the legislative bodies, right? This is the authority of the Constitutional Court to resolve. And then there was also a question about indigenous law. I mentioned previously that indigenous communities and indigenous law and indigenous communities have a legal standing and has the right to request a judicial review. So if they feel that they have been violated or their rights have been violated by a material or a clause or an article or even any wording by a law that they feel has harmed their existence as indigenous community, then they have every right to file a request for judicial review to the Constitutional Court. Thank you.
And now, before we close, in conclusion, based on what we've heard from the speakers, we can summarize the issue of peace in terms of the differences between constitutions of different countries. We see that there are some constitutions that talk about peace, that do not talk about peace, whereas other constitutions clearly state that the remit is about peace, and other constitutions implicitly refer to peace, either when talking about external relations and collaboration, international collaboration, unlike other countries where their constitutions clearly refer to peace in terms of social peace or peace within the country, and it is the topic of this Congress. We also noted that there are several constitutional courts and councils were not requested to seize of cases pertaining to peace and social peace, whereas other courts interpreted these rulings or these texts in their own way, and they managed to offer cumulative case law and opinions based on their own interpretation of the Constitution, giving themselves the remit and the mandate to spread peace and stability in the country. We have seen how constitutional courts and councils, as primary actors aiming to protect democratic principles, especially during elections, and constitutional courts as well can be a factor of stability and an inevitable mechanism to protect human rights, which is a precondition for conflict resolution and ensuring that peace prevails in the country. Empowering individuals, allowing individuals to reach constitutional courts through submitting requests if they feel that a law or action is unconstitutional will give people, will allow people to strongly believe in the judiciary and add their confidence in the decisions and the rulings of constitutional courts, which will reduce conflict and help spread peace and harmony. Before I close this session, I would like, in your name, on your behalf, to express my gratitude for giving me the opportunity to chair this session. I would also like to thank all the speakers for their excellent presentations that have enriched the discussion around this topic that starts this 5th Congress. I would also like to congratulate Indonesia for the excellent and wonderful organization of this conference. And I would also like to express my deep gratitude to the Secretariat of the 5th Congress of the WCCJ, and in particular the Secretary General, Mr. Shnotas Dior, and all his assistants for the preparation, for the quick response to the requests of all participants. Thank you all, and peace be upon you and God's blessings. And now we adjourn this session.
Thank you, Excellencies. Ladies and gentlemen, this is the end of our first discussion. And ladies and gentlemen, the second discussion will be continued after the lunch break, and we expect you to return to your seats in 2 hours or in 1.5 hours. The lunch will be served in Singaraja Hall 1 on the first floor, and the next discussion will be started at 2 p.m. local time. Thank you very much.